Well, if it wasn't official before, it most certainly is now. We are living in an absolute insane asylum. These people are crazy. They have lost their minds. They have lost their ways. They have lost everything. They are too far gone to be brought back, but for by the hand of God Himself. Because anybody who can genuinely propose what I'm about to read to you is beyond the pale. Joe Biden wants to talk about beyond the pale. These people are beyond the pale. This is not America. What in the fuck is going on? We have to change this now. Guys, I don't know what to do. We have to do something, and I don't know what. We have to do it now, though. Because God forbid this go through. And we're at a point now where honestly, I won't even be shocked if it is supported and goes through and becomes a law. Listen to this shit, you guys. So from the New York State Senate, in Assembly, January 6th, 2021. This is A416 active bill. This is that same bill, just in PDF form. The green areas highlight the new stuff, and easier to read what's new, what's added, what's omitted, whatever. All right, so here we go. In Assembly, January 6, 2021, introduced by M. of A. Perry, an act to amend the public health law in relation to the removal of cases, contacts, and carriers of communicable diseases who are potentially dangerous to public health. The people of the state of New York, represented in the House, in the Senate and Assembly, do enact as follows. Section 1. The public health law is amended by adding a new section 2120A to read as follows. Removal and detention of cases, contacts, and carriers who are or may be a danger to public health. Other orders. 1. The provisions of this section shall be utilized in the event that the governor declares a state of health emergency due to an epidemic of any communicable disease. 2. Upon determining by clear and convincing evidence that the health of others is or may be endangered by a case, contact, or carrier, or suspected case, contact, or carrier of a contagious disease that, in the opinion of the governor, after consultation with the commissioner, may pose an imminent and significant threat to the public health, resulting in severe morbidity or high mortality, the governor or his or her delegacy, including but not limited to the commissioner or the heads of local health departments, may order the removal and or detention of such a person or of a group of such persons by issuing a single order, identifying such persons either by name or by reasonably specific description of the individuals or group being detained. Such person or group of persons shall be detained in a medical facility or other appropriate private facility or premises designated by the governor or his or her delegates, and complying with subdivision 5 of this section. Okay, so let's go over that real quick. This is saying with one single order by any of these assholes, they can come and take a single person or a group of people who they suspect might be sick with a communicable disease and put you in a facility. Okay, oh, that seems legit, yeah. 3. A person or group removed or detained by order of the governor or his or her people pursuant to subdivision 2 of this section shall be detained for such period and in such a manner as the department may direct in accordance with this section. Okay, so everybody understands that? For as long as they want and however they want. Okay? Notwithstanding any inconsistent provision of this section, a confirmed case or carrier who is detained pursuant to subdivision 2 of this section shall not continue to be detained after the department determines that such a person is no longer contagious. Oh, that's nice. A suspected case or suspected carrier who is detained pursuant to subdivision 2 of this section shall not continue to be detained after the department determines with the exercise of due diligence that such a person is not infected with or has not been exposed to such a disease, or if infected with or exposed to such a disease, no longer is or will become contagious. What? So we'll go back. A person who is detained pursuant to subdivision 2 of this section as a contact of a confirmed case or carrier shall not continue to be detained after the department determines that the person is not infected with the disease or that such a contact is no longer presents potential danger to the health of others. So the contacts, holy smokes. So if I know you, we work together and they decide to detain me, they can decide to detain you because you were a contact. Are you absolutely fucking kidding me? Okay. After the department determines with the exercise of due diligence that the suspected case was not infected with such a disease or was not contagious at the time of the contact was exposed to the individual, or after the department determines that the contact no longer presents a potential danger to the health of others. A person who is detained pursuant to subdivision 2 of this section shall, as is appropriate to the circumstances, have his or her medical condition and needs assessed and addressed on a regular basis, and be detained in a manner that is consistent with recognized isolation and infection control principles in order to minimize the likelihood of transmission of infection to such person and to others. When a person or group is ordered to be detained pursuant to subdivision 2 of this section for a period not exceeding 3 business days, such persons or member of such group shall, upon request, be afforded an opportunity to be heard. Oh, so they can keep you for 3 days before you can even be heard. If a person, oh my God. Oh, you have to have a hearing now? A medical hearing? Are you fucking kidding me? This is not a thing. Okay, focus. Sorry. I lost my place. Okay. Upon request, be afforded an opportunity to be heard. If a person or group detained pursuant to subdivision 2 of this section needs to be detained beyond 3 business days, they shall be provided with an additional Commissioner's order pursuant to subdivision 2 and 8 of this section, needing 3 business days, and such person or member of such groups requests release, the governor or his or her delegates shall make an application for a court order authorizing such detention within 3 business days after such request by the end of the first business day following such Saturday, Sunday, or legal holidays, which application shall include a request for an expedited hearing. A fucking hearing? Sorry for cussing you guys, but what the fuck? After any such request for release, detention shall not continue for more than 5 business days in the absence of a court order. Authorizing detention. Notwithstanding the foregoing provisions, in no event shall any person be detained for more than 60 days. What the fuck? Without a court order authorizing such detention. Okay, that just went from 3 days to 5 days to 60 days real quick. Holy shit. Okay. Without a court order authorizing such detention, the governor or his or her delegate shall seek further court review of such detention within 90 days. Oh, fuck, it just went to 90 days. Following the initial court order authorizing the detention, and thereafter within 90 days of each subsequent court review in any court process to enforce an order of the governor or his or her delegates for the removal of detention of a person or group issued pursuant to this subdivision, or for review of the continued detention of a person or group. The governor or his or her delegates shall prove the particularized circumstance constituting the necessity for such detention by clear and convincing evidence. Okay, so let's just go over that real quick. First of all, I love the clear and convincing. Convincing evidence is probably more like it. Bullshit. And if you can bullshit your way through it, you can get away with it, no problem. All right, and these mother effers are saying right now that they can come and get you out of your house, out of your job, out of your car, out of your anywhere, and everybody that you've talked to, and throw you in jail. Okay, it's detention. It's fucking detention. Okay, so throw you in jail and not even have to have a court order, not have to have approval from anybody, and not even let you speak up about it for at least 3 days. After 3 days, they'll go ahead and let you be heard, but it doesn't really mean shit because they can hold you for up to 90 days without a court order, is what it's saying. But they can hold you up for 90 days and then get a court order and hold you for however long. This has got so many bad loopholes in it, it's not even funny. Okay. All right, so that was section 7. We're on section 8 now. A copy of any detention order of the governor or his or her delegates, issued pursuant to the subdivision 2 of this section shall be given to each detained individual. However, if the order applies to a group of individuals and it is impractical to provide individual copies. Why would that be impractical? Because there's just so many people? Holy shit. It may be posted in a conspicuous place in the detention premises. Oh my God. Any detention order of the commissioner issued pursuant to subdivision 2 of this section shall set forth 1. The purpose of the detention and the legal authority under which the order is issued, including the particular section of this article. 2. The description of the circumstances and or behavior of the detained person or group the basis for the issuance of the order. 3. The less restrictive alternatives that were attempted and were unsuccessful, and or the less restrictive alternatives that were considered and rejected, and the reasons such alternatives were rejected. 4. A notice advising the person or group being detained that they have a right to request release from detention and including instructions on how such requests shall be made. 5. A notice advising the person or group being detained that they have a right to be represented by legal counsel. This is fucking jail. And that upon request of such person or group, access to counsel will be facilitated to the extent feasible under the circumstances. So if you're really sick, oh, sorry guys, we can't get nobody to you. Oh my gosh, I'm so upset right now. 6. A notice advising the person or group being detained that they may supply the address and or telephone numbers of friends and or relatives to receive notification of the person's detention, and that the department shall, at the detained person's request and to the extent feasible, provide notice to a reasonable number of such people that the person is being detained. B. In addition, an order issued pursuant to subdivisions 2 and 7 of this section requiring the detention of a person or group for a period exceeding 3 business days shall 1. Advise the person or group being detained that the detention shall not continue for more than 5 business days after the request for release has been made in the absence of a court order. Authorizing such detention. 2. Advise the person or group being detained that whether or not they request release from detention, the governor or his or her delegates must obtain a court order authorizing detention within 60 days following the commencement of detention, and thereafter must further seek court review of the detention within 90 days of such court order and within 90 days of each subsequent court review. And 3. Advise the person or group being detained that they have a right to request legal counsel be provided, that upon such request, counsel shall be provided, and if to the extent possible under the circumstances, and that if the counsel is so provided, that such counsel will be notified that the person or group has requested legal representation. 9. A person who is detained in a medical facility or other appropriate facility or premises shall not conduct himself or herself in a disorderly manner, and shall not leave or attempt to leave such facility or premises until he or she is discharged pursuant to this section. 10. Where necessary and feasible under the circumstances, language interpreters and persons skilled in communicating with visions and hearing impaired individuals shall be provided. That's nice. 11. The provisions of this section shall not apply to the issuance of orders pursuant to 11.21 of the New York City Health Code. 12. In addition to the removal or detention orders referred to in subdivision 2 of this section, and without affecting or limiting any other authority that the commissioner may otherwise have, the governor or his or her delegates may, in his or her discretion, issue and seek enforcement of any other orders that he or she determines are necessary or appropriate to prevent dissemination or transmission of contagious diseases or other illnesses that may pose a threat to public health, including but not limited to orders requiring any person or persons who are not in the custody of the department to be excluded, to remain isolated or quarantined at home or at the premises of such person's choice that is acceptable to the department under such conditions and for such period as will prevent the transmission of the contagious disease or other illness, to require the testing or medical examination of persons who may have been exposed or infected by a contagious disease or who may have been infected by a contagious disease or radioactive material or toxic chemicals, to require an individual who has been exposed to or infected by a contagious disease to complete an appropriate prescribed course of treatment, preventative medication, or vaccination, including directly observed therapy to treat the disease and follow infection control provisions for the disease, or to require an individual who has been contaminated with dangerous amounts of radioactive materials or toxic chemicals such that said individual may present a danger to others, to undergo decontamination procedures deemed necessary to the department. Such person or persons shall, upon request, be afforded an opportunity to be heard, but the provisions of subdivisions 2 through 11 of this section shall not otherwise apply. The provisions of this section shall not be construed to permit or require the forcible administration of any medication without a prior court order. Oh, okay, they have to have a court order first. That's cool. It's totally cool. Right? Okay, great. That's great. It's fucking great. So that's the new amended part of this bill. That is A416 in Assembly 416. One of my favorite parts of this bill here is this part. I think it was right over here, where it says that let's see. However, if the order applies to okay, so this says okay, this is 8A. A copy of any detention order of the governor or his delegates issued pursuant to subdivision 2 of this section shall be given to each detained individual. However, if the order applies to a group of individuals and it is not practical, it is impractical to provide individual copies, which means a big ass group of people, okay? It may be posted in a conspicuous place in the detention camp that you're going to be fucking put in. These are kidding me right now. Any detention order of the commissioner issued pursuant to the subdivision 2. Okay, so literally it says that they're going to post it on the fucking wall of the camp that you're going to be in, because there's going to be too many of you to give each and every one of you a piece of paper, because God knows we don't have paper like that. Guys, this is so I'm speechless, and you know what? I'm not speechless very often. I'm really not. I'm not shocked very often. I'm caught off guard quite a bit because I tend to think the best of people, and I'm constantly disappointed. But this is disgusting. I don't even know what to say about this. Meet Assemblyman Nick Perry. This is the asshole that proposed this preposterous bill. He's an immigrant from Jamaica. I say we send him back. He volunteered for the U.S. Army, where he served for 2 years of active duty and 4 years on reserve status. Thank you for your service, you fucking piece of shit. He went to college. So he was a student leader and student rights activist. He got involved with community organizing and gained recognition. Yeah. And then he, where did he fuck? I mean, he must have gone wrong somewhere. Oh, here it is. He was reelected to his 15th consecutive term in the 2020 general election. In the 2016 presidential primary, running as a delegate, pledged to support Hillary Clinton. Fucking dog. Kill the dog. I'm gonna send the dog away with the assemblyman. Anyway. Alright. Perry received more votes than any other candidate for delegate in Kings County. I bet he did. They're really good at receiving more votes than anybody ever, aren't they? Oh, these motherfuckers. So, he's married to Joyce, and they have 2 children, a daughter and a son, and 1 granddaughter, who he wants to put in a fucking concentration camp if he's able to. I guess I'm going to have to be a cartoon forever, because this is unbelievable. Not real. Clear and convincing evidence. I don't even know. I know this dude's an immigrant, and I don't care if you've been here longer than I've been alive. I was born here, bitch. Go away. You're not allowed here. If you don't believe in what we believe in, and if you don't understand that we don't put people in concentration camps, With We don't do that here. Then go back to Jamaica, wherever the fuck you're from. Bye.